brother, sister, Gary Ashmore. Just a quick something about the firm is I guess my dad started this firm when he retired from the probate bench. He was a probate judge here in Dallas County for about 11 years, almost 12 years. And when he decided that it was no longer fun being a judge, he decided to go out on his own. He always tells us that, you know, when he went out on his own, he got a lot of offers from those big firms, and he decided that he never wanted anybody to tell him when he had to stop working. So he said, forget all of those offers, I'm venturing out on my own, and that way I can work for as long as I want to. We just lost, Amen is right, we just lost him in April of this year. He was 90 years old, and he probably worked until he was 89.
That's about right.
In fact, the facility he was in, every time I would walk in, everybody knew he was a judge, he was an attorney, and they're like, your dad has been giving us some advice and talking to us and telling us that we need to talk to you. So he was working till the day he passed. When he retired from the bench, he and Gary started the firm together. And then I joined them many, many, many years later. So now Gary and I own the firm and trying to live up to the legacy that our father left behind. And so if we can just go around, just what made y'all come to Anthology? What made y'all come here today? You already told us checking it out for your friend. Okay. What made you come here today?
I brought him over here because he needs to get closer to me.
Oh, I love it.
It's inconvenient for me to tell him what to do when he's so far away.
Oh, I love it.
I told you the woman's in charge. Didn't I tell you so?
Don't worry about it. Just nod your head and say yes. And then what brings you here, Diane?
I've got the flyer.
Okay.
I see the estate planning, and I think it's about time for me to learn about.
Perfect. Okay, so y'all are gonna have to tell on yourselves.
Wait, why are you here?
Oh, sorry.
Do what?
Are you part of this facility?
I am working with Legacy Therapy, so I will be the director of the outpatient therapy company that's here. So
Oh, nice. Oh, perfect.
What's your name?
Whitney.
Okay, all right, super.
Whitney may be the most important person in the room.
I was just going to say.
Yes.
You're right.
Yes.
She keeps them able to go to the law room.
That's right.
And you know what? That's important because not all facilities are created equal when it comes to that piece of it. So that's fantastic. So I'm going to ask y'all to raise.
Hold on, there. So this is Hamid Naragi. He's one of our associate attorneys. No, he's our lead family law attorney. He's not here anticipating anybody getting a divorce here. But something that he brings unique to the firm is he's a divorce coach. A lot of people don't know what that is, but it's allowed us to open a lot of doors for a lot of folks with therapists, with other facilities, and it just brings a different dynamic to the firm as it relates to dealing with family law issues and practices. And then of course we've got Dawn, who's our director of marketing. Mm-hmm. We've got Luke, who runs the show, video production guy. So if y'all don't mind, excuse me, we are recording this so that we can have it as a presentation. We do a lot on social media, we do reels, we do all sorts of fun stuff.
Right, and so then if you want to access this information later, it'll be on our YouTube. If you're like, hey man, what was that Lori said again? We'll post it and we'll send you guys out the link.
Yeah.
Sitting in the back is Sterling Day. She's our PR rep. Also, she's instrumental in bringing us to Anthology. And of course, everybody knows Sherry, is that right?
Yes,
Sherry. Everybody knows Sherry. Okay, all right, go ahead. I'm sorry. I didn't mean to interrupt you.
Anything else?
No, I'm not.
You gotta love Big Brother. You gotta love the bantering that goes on. It's never a dull moment at our firm. We're not your typical attorneys. We have fun. We work very hard, and we have fun with what we do. So, how many of you actually have your wills and estate planning documents in place? Okay. How many of you have reviewed your estate planning documents over the last year? Ooh, very nice. Very nice. Oh, okay. How many of you have your documents in a safe place in your residence? And, okay. We always tell people, the first thing we say is don't ever put your important documents in that safe deposit box. Ever, 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 because it is such a pain to get to. If you're incapacitated or once you pass, nobody can access it but you, and they have to go through a court process and a judge just to access that safe deposit box. So that's the first bit of advice that we let everybody know about. So whenever we do, we're not doing a clicker or anything, right? Okay.
How we move into the next iteration?
Oh, I'm sorry.
Will you the clicker?
Oh, there we go.
I'll bring the clicker, so I'm sorry.
That's okay.
You're gonna have to be your own clicker today.
You're good. I will multitask. Okay, so the key topics, what we're going to talk about today is just, estate planning for senior living transitions, because, if you're transitioning into senior living, you're going through a lot of changes, and you just have to make sure that everything is exactly as you want it and as you need it. Dad always told every single client of ours, no matter how young or old they were, and Gary and I follow this tradition, that inheritance is a privilege. It is not a right. I can't tell you how many kids we have come to us that say, Mom just passed away and Dad is spending all of our inheritance. And we have to say, number one, sorry for your loss, but number two, inheritance is a privilege. My advice to all of my clients is spend every penny that you have. Enjoy life, right? So inheritance is a privilege. It is not a right. There are a lot of attorneys out there that will just say, no matter what your situation is, you need all of these documents. We don't practice that way. We tailor-make every estate plan that we do. We get a listing of your assets, the details of your assets, and what your goals and objectives are to make sure that you are getting the documents that you need. And I'm going to go a little bit off script if that's okay. I did a presentation at an independent living facility a few years ago, and I had one of the residents come up to me and she said, Lori, I wish I would have met you 2 weeks ago. You did such a great presentation, you explained it, and I understood everything you talked about, but 2 weeks ago I've had an attorney do all of my documents, but do you mind taking a look at them? I said, not a problem, scheduled another time when I was going to be going out there, and she brought this beautiful, beautiful brown leather binder. We've all seen those. Unfortunately, we see a lot of them in California. And she had her revocable living trust. She had her pour-over will. She had all of her powers of attorney, all of her disability or incapacity planning documents. So everything was perfect. And so whenever I see a trust, you've got some attorneys that's just their normal practice. Everybody needs a trust. I don't take that philosophy. There are reasons to have a trust. There are reasons where you don't need a trust. So she and I started talking about, first thing I'm asking her, well, I see you have a trust. All of your documents look to be in order, but tell me a little bit about your assets. She goes, honey, I sold my house many, many years ago when I moved into this facility, and it's what I've been living off of, and I get my Social Security, and that's pretty much, that's it. I'm like, stocks, bonds, investment accounts, any other real estate. She says, honey, I don't have any of that. I have a little bit of savings, not much, and I live off of my income every month. She didn't need a trust. Did not need a trust. There were other alternatives that were available to her. Instead of paying $3,500 for that trust, she could have done something for about $800. And I didn't have the heart to tell her that because I knew she would just fixate on the fact that she did not need a trust. And the documents that she had were perfect documents, but they just weren't needed for her. So I always tell people, whenever you're talking to an attorney of any kind, Gary's always said, and we have a video that says, you need to pick your attorney like you do your doctor, right? These days, it's a long-lasting relationship. We are not the one-and-done kind of law firm. We don't just prepare a document, hand it to you, and say, have a great life, but we want to grow with you. We want to make changes with you. And you've got to like, what do you say, how we look, how we smell, what we sound like.
How office you're in, all of it.
And I tell people, if you have a gut feeling about something, you got to follow that gut. Always, always follow your gut. And so that's just part of my story about what documents you need and why you need them, because not all documents are created equal. And again, a document that fits you may not fit you. And you want an attorney that can tell you all of that information. Problems avoided because of estate planning. You know, back in Dad's day when he was a judge, you could probate, when someone would pass away, you'd file it with the court within a week, should you choose to do so, and within 10 days, within 2 weeks, you had the hearing and you were off with the races administering the estate. This day and age, unfortunately, once someone passes away and we file the initial document, it may take 3 months, 4 months, 5 months, 6 months just to get it in front of the court. So you also need to take those considerations and make sure that all of your documents are where they need to be for that smooth transition. We do have checklists that we have provided to you of just things that y'all need to think about. Not every item on the list will pertain to you, but they are just things that you really need to consider. And then estate planning for adult children. We tell people, when we have the older clients, the planning I'm doing for them isn't just for what they have, but it's what do your kids have and how do we need to protect those assets for your kids? How can we protect those hard-earned dollars and that property to make sure that when it gets to your kids' level, if they get divorced or if they get sued, nobody can touch that money. It is 100% asset protected for them. And then we have just some, we have frequently asked questions in here as well. Okay. All right. Oh, there we go. Okay, so we have a foundation of documents that we recommend in every single situation. It's the foundation of documents that everybody needs. First, of course, your living will. We'll start with the bottom. That's the one that states when you pass away, what do you want done with your assets, number one, and number two, who do you want to take control over those assets to make sure what you want is what happens. And that's an important task. I had an elderly client, a husband and wife, come to me and they had 3 kids. And they had listed all 3 of their daughters as the executor of their will, and the executor is the one that takes control of all of the assets, pays all of the debts, and then makes the distribution to all of the beneficiaries under the will. We drafted everything. They were about to sign everything, and they called us and they said, our daughter got so angry with us that she was listed 3rd in line to be our independent executor. And she got so angry that she said, unless we list her first, she doesn't want to be left in the will. She doesn't want to have anything to do with us. And she's just cutting off all lines of communication.
Wow.
What do you think my advice was to them?
Let her go.
No, my advice was list her first. Because I can promise you when the day comes that y'all are gone and she's having to step into that role, it is a thankless job. It is not an easy job. And at that point in time, she will be regretting ever opening her mouth. Dad would tell Gary and I've listed y'all as the executor, and he and I are both like, we don't want it. Give it to our other siblings. It's an important job, but it is a thankless job. There's a lot to do, and especially for those that don't have all of their affairs in order. The next important document is the statutory durable power of attorney. This is the document that says if you are incapacitated, who do you want to step into your shoes to handle your finances and take control of everything? In this document, you make the very important decision whether you want it to take effect when you're incapacitated or if you want it to take effect immediately. Again, there are attorneys out there, and again, there's no right or wrong answer to anything. It's just personal preference, but I do have some attorneys that default it takes effect immediately when you sign their documents. I personally don't believe in that because you know what? If it needs to take effect immediately, perfect. But stay in control of your own assets for as long as you want to and for as long as you can. The next one is the medical power of attorney. Again, if you are incapacitated, who steps into your shoes to make your medical decisions? These are important documents because these are your finances and these are your medical decisions. You want to make sure that you have someone in place and not just obligation of, I've got my 3 kids. Do I go in, chronological order? Do I go in location order? You want to make sure whoever you've chosen to serve in these capacities will abide by what you want. And I know, with Dad, Gary and I have always been, and we told him this until the day he passed, I may not agree with the medical decisions you're making for yourself, because he was coherent and he had capacity. I said, even though I may not agree with it, we will promise that we will respect your wishes. Your wife may not agree with it, your other kids may not agree with it, your siblings may not agree with it, but we will make sure that it is respected. And that's important. That is so important. The next document is the living will, which is the advance directive. This is the document that says, what do you want for end of life? If you're suffering from that terminal condition or irreversible condition, do you want to be hooked up to life support? Do you want to just be kept comfortable? You're making that decision now. I don't know, do y'all remember the Terry Schiavo case in Florida years and years and years ago, where she was in an irreversible condition. She had no brain activity. Her husband said she never wanted to be hooked up to life support. You have those kinds of conversations with your spouse, but she never signed anything. And of course, her parents are like, absolutely not. We don't know. We want her hooked up until we can feel comfortable that she truly has no brain activity. It became a lawsuit, and it was dragged out in the courts for years and years and years.
9 years.
Right. And so if she just would have had this document, all of that could have been avoided, number one. Number two, for these documents right here and some of the documents that are on the next screen, if you have any grandchildren or friends that have children or grandchildren that are 18 years old, they need these documents. And it's a horrible thing to have to talk. I mean, my daughter's about to turn 18, and it's a horrible conversation to have with them of, okay, if something happens to you, do you want to be hooked up to life support? My God, she's 18. But the problem is at 18, she's an adult, and she needs to have these documents in place as an adult. Next one, we'll do HIPAA authorization. Of course, every time you go to the doctor's office or you go in for a procedure at the hospital or an outpatient clinic, they always have you sign the HIPAA authorization. This just states who can get to your medical records. I tell people you need to make sure you have who you want here, because it can be abused. If, say, later this afternoon I have a doctor's appointment and Gary's on my HIPAA authorization, and he knows I haven't been feeling well, I haven't been looking great, I've been losing weight, I've been tired, and I go to my appointment and then he can't get a hold of me. He doesn't know where I am, he can't find me. He's like, what in the world did the doctor say? What's going on? If he wanted, he could go into my file and fax that HIPAA authorization to my doctor's office and get all of my medical information. But I have had clients and we have had family members that haven't had that in place, and you can't get anything. Again, with Dad, he broke his wrist. I was with him for 6 hours in the doctor's office. They x-rayed it, they talked to him, they casted it. We went home. Of course, the whole family's like, what'd he break? I'm like, his wrist. And they're like, okay, what bone? And I'm like, I don't remember. So I called the doctor's office the next morning and I'm like, hey, I was just there with my dad. We were there for 6 hours. What bone was it he broke? I can't remember what you told me. Sorry, we can't talk to you. We need his HIPAA authorization to give us, we know you were here, and yes, he said we could talk to you while you were in the office with him, but now we can't talk to you, you need that HIPAA authorization. So it is a very important document. Then that brings us to revocable living trust and beneficiary designations, okay? Here's what I tell people. Whether someone comes to me with $5,000 worth of assets or $500 million worth of assets, whether anyone comes to me with 2 assets to their name or 2,000 assets to their name, every single asset can be assigned in one of 2 buckets. And it's that simple. The first bucket is a non-probate bucket. The second bucket is a probate bucket. If it's in that non-probate bucket, it's a contract. I can define it, okay? If I have that life insurance policy where I've designated the beneficiary, it's in that non-probate bucket. So much so that if I designated Gary as my beneficiary on that life insurance policy, and under my will I say I want the proceeds from life insurance policy ending in 123 to go to Luke, which one do you think controls the beneficiary designation? Luke doesn't get a dime of it. Gary gets it because that beneficiary designation on the policy itself is a contract. The will is not a contract. Okay? Any retirement account that you've designated a beneficiary on, again, non-probate bucket. I can take that person with 2,000 assets to their name and I can tell them what they need to do with each asset to get it into that non-probate bucket. The beautiful part about the non-probate bucket is you don't have to go through the probate process when you pass away. It passes outside of probate. Okay? When it passes outside of probate, it's private. Okay? Nobody knows what it is except for the beneficiary. The other document that passes outside of probate is your revocable living trust. Okay? It's a trust, and I am doing more of these now because it avoids probate, and it's such a smooth transition should the creator of the trust become incapacitated, disabled, or when they pass. And what it does is all of the assets are dumped into this revocable living trust. You have to have a qualified attorney, though, because there are certain assets that can be dumped into it, and there are certain assets that you don't ever put in the trust, but you designate the trust as a beneficiary. Okay? But anything that's in this revocable living trust, if that person is ever incapacitated, nobody knows what's in this trust. It is completely private. A judge never has to get involved. A judge can't get involved with any of these assets in this trust. And when the person dies and passes away, the next trustee just steps in and continues administering the trust. Okay? Anything that is not in that non-probate bucket defaults into the probate bucket, and that's where your will controls. So I have people say, well, if I do beneficiary designations on everything and I have my revocable living trust and I've signed it and I'm going to put all my stuff in there, I don't need a will. Why are you drafting a will? Everybody needs a will because there's always that one asset that you either forgot about, didn't know about, or recently purchased that was never, no beneficiary designation to it and was never put into the trust when you pass away. If you do not have a will for that asset or for any of your assets that are still in your individual name, the judge takes control of everything and the state of Texas determines who gets it. And probably 8 times out of 10, it's not what you want. Okay? Excuse me. All right, designation of guardian. We talk about the powers of attorney, right? Medical power of attorney and financial power of attorney. But you also need is there a designation of guardian on the next page? Okay, so we have a huh? Oh, I can't go back.
Use the arrow keys.
Oh, use the arrow keys. Oh, not that way. Oh, designation of guardian, thank you. So even though you have your powers of attorney that says if you're incapacitated, who steps into your shoes to make medical decisions and financial decisions, you still need this designation of guardian. I can't tell you how many clients I have that have this, and it has saved us. The reason is this. Say, God forbid, I'm in a car accident, and I'm in the hospital, and I'm going to be fine, but they perform surgery, they have to keep me in a medically induced coma, and they have to do another procedure, but I can't give informed consent because I don't have capacity at that time. And the doctors come out and say to the family and says, hey, you know, Lori's going to need this other procedure, she can't give consent, but we need to do it kind of fast. Gary has my power of attorney. He's first in line. He steps up and says, here's her power of attorney, I'm her brother, do the procedure. Because we are in such of a litigious society, because again, attorneys muck things up, the doctors can say, whoa, wait a minute, Gary, we acknowledge and understand you are her agent under the power of attorney, but we want a judge to order us to do this procedure, and it just adds an extra layer of insulation for any liability purposes if anything goes wrong. Great. Gary now has to go to the courthouse, has to file the application to become my guardian. The problem in my particular situation is I am not married. I've got 2 kids that are not adults. And so it would go to my parents, and they would get to decide who my guardian would be. We lost our father. Mother is elderly, so she won't do it. It goes to my 3 siblings, okay? In this document, my 3 siblings get to argue over who it's going to be, and believe it or not, especially when we're dealing with parents, you would be surprised. As much as kids love each other and get along, or you think they love each other and you think they get along, we see it more times than not, especially when money is involved. They're going to start fighting over who the guardian's going to be, okay? And that's just a fact. With my 3 siblings, say for instance, I've got, Gary, who I know will do what I want, even though he may not agree with it. But say for instance, I have a sibling out there where I'm like, okay, I am more of, give me Western medicine. If I'm not feeling well, give me something that's going to stop the pain, right? And say I have a sibling out there that takes the more holistic approach and says, hey, no, absolutely no medications. It's all about holistic. I may not want that sibling in control of my medical decisions, right? Because even for our father, if we were ever to argue over his medical decisions, he had this designation of guardian and got to choose the order of who he wanted to make sure abided by his wishes and not what they want. It also allows you to say finances. I find with a lot of clients that have more than 1 child, there's always that 1 child that doesn't quite handle finances the way they should. And if they've got $5 in their pocket, it's burning a hole and they've got to spend that $5 as quickly as they can. Well, under your financial decision making, if you're incapacitated, you may not want them. You love them. But in this document, you can say, if I ever need a guardian over my finances, I don't want it to be this child. I tell the parents, write a note, either have it with your documents or give it to me so that if we ever have to use this document, we can at least give that child a note from you explaining why you don't want them to make those decisions for you. Okay. Designation of guardian for minor children. If you've got kids that have minor children, you can tell them, hey, I've learned some information today. My will states who I want my children to go to because they're minors if I pass away, okay? But what happens if I'm incapacitated? And say I want a sibling that lives in Colorado to take the kids and let the kids live with them, and they are now their parents. But if I'm incapacitated and I'm in a hospital, I have filled out this document to say who takes control of my kids, who handles their finances. I don't want them to move to Colorado. I want them to stay local. So I may choose in this document, it's a standalone document, and I may choose, you know what, if I ever become incapacitated, I may want my neighbors to step in to be the guardian of my kids to make sure that they stay in the house and that their lives are not interrupted by my incapacity. Okay, so it is a very important document for those that have minor children. Personal property memorandum. You have to remember, if you die and you have your will and you put everything in that probate bucket, it's public record. For instance, Michael Jackson, when he passed away, if he didn't have any trust set up and that state was like Texas, anyone could go to the courthouse, pull his inventory, and know exactly what he had when he died. And when I say know exactly what he had, it's not something that says, yeah, when he died, he had about $10 million worth of assets. No. It's when he died, he had this house, and this is what it was valued at on the date of his death. When he died, he had the Wells Fargo account ending in 123, and it had $2,222.22 in it when he passed away. It's that detailed. When he died, he had these stocks, and he had this many shares. It was valued at this amount on that day, and this was the total amount when he passed away. Revocable living trust instead of just the will. Disposition of remains. Unfortunately, we see more arguments with this, and it sounds like such a morbid document. And again, these are just the foundation documents. It states when you pass away, who do you want to make sure that your remains are disposed of as you want, okay? We had a family, it was a second marriage. The wife said, this is where I want my husband buried. The adult kids from a prior marriage said, no, 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 that's not what we want done with Dad. Dad was in the morgue for months while they fought in court to determine where Dad was to be buried and how Dad was to be buried. With this disposition of remains, you're choosing your agents, who you want to make those decisions, and you can also do special instructions to say either I have a prepaid funeral contract or I want to be cremated and I want my ashes scattered blank. Again, it sounds like such a morbid document, but it is something that needs to be considered, thought about, and discussed. Oh, arrows. Okay, so I know that was a lot. And again, these are just the checklists, and everything I just talked about is the foundation that everybody needs. Not the revocable living trust, but it is the last will and testament, the medical power of attorney, the statutory durable power of attorney, the HIPAA authorization, the living will that talks about life support, designation of guardian, disposition of remains. Those are the foundation of all of the documents that we prepare, and we have a package, whether it's a will package or if it's a trust package, because we need to do that revocable living trust for that client. Trusts aren't just for the wealthy. Trusts aren't, what a trust does is, yes, there are reasons to do a trust for tax planning. And we know this year the estate tax exemption is $13.61 million that you can pass away with and not owe any estate tax. We know, as it stands today, next year it goes to about $14 million. We know January 1 of 2026 it goes to $5 million, which is a huge decrease. Indexed for inflation, it'll probably end up at about 6.2 or 7 million. And we know that. That's written in the books right now. However, I don't ever get political. I don't talk politics. Regardless of anyone's political affiliation, we know what the campaigns are. And we know if Vice President Harris, her campaign right now and platform is, if she is elected, and if the Democrats take control of Congress, and they're calling that the trifecta, so presidency, House, and Senate, they are wanting to reduce the estate tax exemption amount to $3.5 million. And that includes all of your assets. It's not just your house and your bank accounts. It's if you have that revocable living trust, it's the amount of money that's in that trust. It's your retirement account. It is your life insurance. We always tell people you are worth more money on paper than you are in your mind. And we always tell people, list out all of your assets. We have a client right now, he's a young man, and he's like, I'm broke. And Gary and I are like, okay, we know what your assets are. We know what you paid in taxes. You're not broke. List it out, because you're going to be like, oh my gosh, like, whoa, I didn't know I had that much. But what a lot of people don't understand is if they have $1 million, $2 million, $3 million, $5 million life insurance policy, guess what? That policy alone, if the estate tax exemption amount gets to $3.5 million, puts you in an estate tax situation. So you've got the trusts that are there for non-tax reasons. It's just to make the transition smoother. But you also have the trusts and other vehicles that are there if you need tax planning, if you need asset protection right now. So again, it is so important. I've got clients that say, no, we don't really feel comfortable letting you know what all of our assets are. I'm like, I respect that, but for me to do my job as best as I can for you, I need to get, I'm not asking to be nosy. I am asking to make sure that your estate plan is exactly what you want.